My name is Faye Sonier, and I'm legal counsel with the Evangelical Fellowship of Canada, and I'll be chatting today with Don Hutchinson, Vice President and General Legal Counsel of the EFC, about the recent Christian Horizons decision that was released in May 2010 and its impact on evangelical churches and charities. Could you tell us a little bit about the case, maybe the facts, and what the final decision was, I guess, on appeal?
The case is about an employee who was working with Christian Horizons for approximately 4 years before she entered into a same-sex relationship, which ultimately led to her resignation from Christian Horizons. Then she filed a complaint with the Ontario Human Rights Commission. There was a hearing before the Ontario Human Rights Tribunal. That decision was appealed to the Ontario Divisional Court, and what came out of those decisions are three things where there was agreement. The first point of agreement was that Christian ministries, Christian communities, congregations, denominations, Christian organizations have a right to exist in Canada and to define themselves as being faith-based and to establish themselves with a faith-based staff. It's very important, however, to remember that the question is being answered by a tribunal or by a court that isn't necessarily Christian. So when we define ourselves, we should take off our Christ-colored glasses and look at ourselves the way the world sees us to make sure it's very clear who we are. The second thing that they agreed upon was that there wasn't a problem with the fact that Christian Horizons was receiving provincial funding. Canada has no such thing as a separation of church and state. In fact, in Canada, we have a long history of cooperation between the church and state. The church operates in its sphere, influencing public policy, engaging in ministries that assist those in need, and the state operates in its sphere, not interfering with the church unless the church is doing something that would be harmful to Canadian citizens or if there's some other legitimate state need. The third point on which the two were in agreement is that it is absolutely necessary for the leadership of Christian ministries and congregations in their employment practices to review the position descriptions of each person on staff and to include in those descriptions why it is essential to share the faith and lifestyle commitments of the religious community.
So there was some concern that people of the same faith or co-religionists would no longer be able to serve people who didn't serve their faith outside of that community. Is that still possible, and has that been addressed?
That concern's been addressed. Christian Horizons certainly is serving people who don't necessarily share their faith. And there's one thing that's not perhaps unique, but it's extremely special about evangelical Christianity, and that is our desire not just to care for ourselves, but to serve others. And the Divisional Court has affirmed that principle again, that there's a place in Canada for Christians to gather together for ministry to others outside of our own four walls.
And now, this was an Ontario decision. Does it apply to, say, BC or any other provinces across Canada and the charities residing there?
There are aspects of the decision that would have strong impact in other provinces. For example, other provinces also have legislation that grants the rights to Christian communities not only to exist but to be selective in their hiring practices. What is different about Ontario is that Ontario has this requirement, a legitimate occupational requirement, that says you have to identify in the job description of the individual concerned why it's necessary for them to share the faith and the lifestyle practices of the community and how that impacts the job that they're doing.
Now, some have argued that this sort of provision is discriminatory because it allows co-religionists, again, people who believe the same thing, to come together and not hire people who don't share their beliefs. Do you hold that position?
Well, it's not discriminatory because what the legislation does is recognize that there are a number of different types of organizations that can exist and be selective in their hiring without violating human rights legislation. And so in addition to, in this instance, a Christian ministry organization, there might also be an ethnic group. So we see Greek cultural centers or we see Armenian cultural centers, and they're allowed to hire just Greeks or Armenians for the work that they're doing. It's the same type of thing, that here we have a group of Christians who have a common faith, common lifestyle expectations, a common understanding, as it were, of the Bible, who are being recognized with a societal right not only to exist, but to maintain that Christian community in the work that they're doing.
So it seems like consistency is important when these charities look at these job descriptions to make sure they're consistent with Heintz versus Christian Horizons. Is that true?
Consistency is very important in two lights. The first light is consistency in requiring all people in the organization to meet the faith standard and the lifestyle policy standard. The second is that lifestyle policies generally list several areas of prohibited behavior and may also list areas of acceptable behavior. Violations of prohibited behavior should be treated in like manner by the organization. There are no greater or lesser sins.
And do you think the interpretation that the Divisional Court made regarding charities and their abilities to serve individuals who don't share their beliefs, are there going to be other similar court challenges in the years to come?
I suspect there will be, because there will be people in Christian Ministries or other faith communities who may change their beliefs slightly, may change the way they want to live their lives, but they enjoy the community, they enjoy the organization they're working with, and they want to stay. And the only way they may find themselves in a position to try and stay is to file a human rights complaint and pursue this type of action.
Now, you mentioned that it's important for charities, at least in Ontario right now, maybe across Canada, to look at the job descriptions of each employee. Can an executive director or the leadership team of these charities do it themselves, or should they consult a lawyer for something like this?
In many instances, charities will be able to do this for themselves. It could be very helpful after you've drafted position descriptions and tried to align them or make sure that they are aligned with your statement of faith and your lifestyle policy, to have them reviewed by an employment law lawyer.
Now, you mentioned at the starting when you referenced Christ-colored glasses and how non-Christian individuals or organizations or even the courts perceive charities or churches. Communication seems to be important. Can you elaborate on that?
Communication is very important. First, when we're defining who we are, it is essential that we define ourselves in a way that recognizes that those who are looking at us may not interpret the Bible in the same way that we do. Second, we'll be dealing with the media if there's this type of a complaint file. It's very important to realize that the media is trying to put people on their defensive, get a good soundbite, and really we have nothing to be defensive about. We are adhering to rights-granting sections of human rights legislation, and we're able to say that. We're doing good work, we're caring for people on the street, or we're engaging in religious worship. We should be able to say that. There's no need to defend doing the right thing.
Should churches or evangelical organizations be afraid?
Churches and evangelical organizations need not be afraid. The reality is that in Canada today, you cannot make it yourself absolutely lawsuit-proof or human rights complaint-proof, but we can take the reasonable steps that provide a good defense in the event that somebody files a lawsuit or starts a human rights complaint. We need to just carry on doing the things that Christ has called us to do, having wisdom in the way we do it, and confidence that He's still on our side.
So to wrap up, Don, what would you say are the top 3 things that charities or their boards or leadership should do now in light of this decision?
Number 1, review your statement of faith and your lifestyle policy to ensure that it's something that is understandable outside of just your organization. Number 2, take a look at every position description in your organization. Make sure that the position descriptions indicate why it is important to share faith and accept the lifestyle policies, as well as the general responsibilities of the job. Number 3, don't be afraid. This is a time to continue doing what Christ has called you to do, and accept the additional wisdom that we can gain from reviewing these types of decisions of the courts and human rights tribunals.